The freedom of speech and expression guaranteed under Clause 1 of Article 105 or 194 is different from that which a citizen enjoys as a fundamental right under Article 19, Clause 1, Subclause A. The freedom of speech as a fundamental right does not protect an individual absolutely for what he says. The right is subject to reasonable restrictions under Clause 2 of Article 19. The term freedom of speech, as used in Article 105, means that no member of Parliament shall be liable to any proceedings, civil or criminal, in any court for the statements made in debates in Parliament or any committee thereof. The freedom of speech under this article cannot be restricted under Article 19, Clause 2. Clause 1 and Clause 2 of Article 105 protect what is said within the House and not what a member of Parliament may say outside. Accordingly, if a member publishes his speech outside Parliament, he will be held liable if the speech is defamatory. Besides, the freedom of speech to which Article 105, Clause 1 and Clause 2 refer would be available to a member of Parliament when he attends the session of Parliament. If the order of detention validly prevents him from attending a session of Parliament, no occasion arises for the exercise of the right of freedom of speech, and no complaint can be made that said right has been invalidly invaded. In M.S. Sharma versus S.K. Sinha, AIR 1959, it was contended by the petitioner that the privileges of the House under Article 194, Clause 3 are subject to the provisions of Part 3 of the Constitution. In support of his contention, he relied on the decision of Supreme Court of India delivered in Gunapati Keshav Ram Reddy versus Nafisul Hasan and State of Uttar Pradesh, AIR 1954, in which the Supreme Court directed the release of petitioner on the ground that he had not been produced before magistrate within 24 hours of his arrest, as provided under Article 22, Clause 2. This decision therefore indicates that Article 105 or 194 was subject to Part 3 of the Constitution. However, in M.S. Sharma versus S.K. Sinha, AIR 1959, the majority did not follow the decision in Gunapati's case and held that the privileges under Article 194, Clause 3 would not be subject to the fundamental rights declared under Part 3 of the Constitution. Sharma's case was considered with the application of Article 19, Clause 1, Subclause A and Article 21. The court held that in case of conflict between the fundamental rights under Article 19, Clause 1A and privilege under Article 194, Clause 3, the latter will prevail. As regards Article 21, on facts, the court did not find any violation of it. Thus, this decision indicates that privileges are not subject to Part 3 of the Constitution. In power, privileges and immunities of state legislature, reference AIR 1965. The proposition laid down in Sharma's case was explained not to mean that in all cases the privileges will override the fundamental rights. The majority opinion in this reference said, "We do not think that it would be right to read the majority decision of Sharma's case as laying down a general proposition that whenever there is conflict between the provisions of the later part of Article 194, Clause 3 and any of the Part 3, the latter must always yield to the former. The majority decision therefore be taken to have settled that Article 19, Clause 1, Subclause A would not apply and Article 21 would. The same position was retreated by the court in Raj Rampal versus Honorable Speaker Lok Sabha 2007, where it held, if a citizen, whether a non-member or a member of the legislature, complains that his fundamental right under Article 20 and 21 had been contravened, it is the duty of this court to examine the morals of the said contention, especially when the impugned action entail civil consequences.